Hello, everybody. Hello. Thank you for choosing Truthfully Speaking. I am your host, and my name is Cree. If you all are able to hear me, if someone could let me know um, in any way, shape, or form, I'm not sure. Last time I went live using this format, I went back over the video and and I couldn't even hear myself. However, I apologize for my tardiness. Let's get into it. All right, there is two parts for why I am doing this live tonight. The first part is that the picture that I used in the thumbnail is because there is some discrepancies going around online pertaining to Quadajah Johnson's facial features, and they're having bruises, her having being a swollen knot on the top of her eye, left side. I believe that they're trying to express that there is a bruise there. However, I was able to get my hands on the original photo that was taken of Quadajah at the time of her arrest from 9/5/2025. So I used that picture to show proof that although I don't and I am not accepted or looking to be accepted, right, in the other groups, I am an individual, though, that is about truth, even when it comes to myself. So I felt the need to speak out to say, hey, once again, Trina, in my opinion, is being honest. In my opinion, once again, who am I to not release the proof that I have to show that it doesn't seem as though she has any type of bruises, abrasions, marks of any sort on her face. So I just need for me and my platform to stand out and say, hey, Trina was not lying, and I stand behind her and what she said in regards to the picture that's floating around, trying to insinuate that there is a knot on the face of that young lady's, that there's a knot on that young lady's face. However, Real TTV was told by myself that in advocacy, you don't have to perpetuate lies in order to stand out for whomever it is that you are, advocating for. And so she cursed me out. And after she cursed me out, she kicked me off of her panel because I came directly to her pertaining to her lying for Carlos and for Wu, and then misrepresenting what I was saying. Right? Now we have a supporter for Romika and a supporter for Holly coming together as one to say that the video is true, the picture is true. Then I have my picture that is the thumbnail. Now that is her picture directly after being arrested. That is the picture right there. Okay. So now we got that part out of the way. Let's get into the main event. Back in 2014, Quadajah Quadajah Monique Johnson, best known as Holly Johnson, was into a criminal case and was brought in as a witness. She, as well as her mother. Hi, Terry, sweetie. Thank you. And it was in Lake County, and it was People versus Anaya Whitaker, which is the last name, of course, of the defendant. Now, I want to read the gist of this, where it leads up to where Quadajah Johnson and LaTanya Johnson comes into play, which is her mother, and of course, it's her. And so I am seeking the understanding is these CCs are saying that witness number 3 is incredible. Although in the court of law, only one person was spoken to be biased. So let's pull to see, is the defendant in the case that is presiding in 2020, started in 2025, that is continued into 2026, is that individual credible? Is the question I have, and is the question that I'm posing to anyone that comes across this live and or anyone who sees the thumbnail. All right. So, 2018 Illinois appellate. The people of the state of Illinois, plaintiff appellee versus Jason C. Anya Whitaker, defendant appellant. Appellate Court of Illinois 2nd District, June 15, 2018. This order was filed under Supreme Court Rule 23 and may not be cited as precedent by any party except in the limited circumstances allowed under Rule 23E1. Appeal from the Circuit Court of Lake County, number 14 CF 754. Honorable James K. Boris, Judge presiding. Presiding Justice Hudson delivered the judgment of the court. Justices Shostak and Spence concurred in the judgment. The order held. The trial court abused its discretion in admitting gang-related and other crimes evidence, which was irrelevant and could not be deemed harmless. Thus, we reversed defendant's conviction and remanded for a new trial. Defendant Jason C. Anaya Whitaker appeals from the judgment of the Circuit Court of Lake County, finding him guilty of the unlawful possession of a firearm by a felon because the trial court abused its discretion in admitting a recorded telephone conversation and certain testimony, both containing gang-related evidence. We reverse and remand. Now, this is the background. And you are more than welcome to go, and I love for you to go and fact check. However, I'm only going to read, since now that I've already given the introduction, I'm only going to read the portion of where, Holly comes into play and her mother. And then her testimony on the stand. The following was established at the trial. At approximately 1:30 a.m. on March 24, 2014, Officer Oscar Galazzaro of the North Chicago Police Department was patrolling a high-crime residential area As he approached 2317 Honor Street, he observed a silver Pontiac parked in the driveway. He did not see the doors open, the interior light come on, or anyone exit the vehicle. The vehicle was occupied by two men. Defendant was seated in the driver's seat and Damon Duffy was in the front passenger seat. The Pontiac was registered to LaTanya Johnson from Waukegan. Officer Galarzo decided to investigate. Officer Galarzo approached the driver's side window and asked defendant where he lived. Defendant responded that he lived with his brother at 2317 Honor Street. When defendant could not provide any proof of where he lived, Officer Galarzo asked him for consent to search the vehicle. Defendant consented. Officer Galarzo had both defendant and Duffy exit the vehicle. During the search, Officer Galarzo found a cannabis cigarette near the front passenger side door and a loaded semi-automatic handgun protruding from beneath the rear of the driver's seat. Officer Galarzo also found a backpack belonging to defendant on the rear seat. Defendant told Officer Galarzo that he had been dropped off at 2317 Honor Street. According to Officer Galarzo, defendant was evasive in answering who had dropped him off. Defendant stated that as Officer Galarzo arrived, defendant's girlfriend and another female, both of whom had been in the vehicle, left the scene on foot. Defendant added that because it was cold, he and Duffy had decided to sit in the vehicle. Defendant did not mention anyone having been in the backseat of the vehicle. The handgun was analyzed at the crime lab. The parties stipulated that there were no DNA or fingerprints on the handgun that were suitable for comparison. Officer Mark Keski of the North Chicago Police Department was one of the backup officers. When he arrived, he saw only two people in the Pontiac, one in each of the front seats. He did not see anyone exit the vehicle before defendant and Duffy did so. Defendant did not appear nervous during the search. According to LaTanya Johnson, she owned the Pontiac and on March 23, 2014, had loaned it to her daughter, Quadajah Johnson. Although she had a FOID card, she denied owning a firearm or having one in the Pontiac. She told the police that her daughter might have loaned the Pontiac to defendant. Quadajah Johnson lived with her mother on March the 24th, 2014. She and defendant were friends. At around 9:30 p.m. on March 23rd, 2014, she loaned defendant the Pontiac so that he could drive to work at a bar called Frank's. She later drove with someone to the bar to see if defendant was there. Later, she saw defendant on Honor Street. According to Quadajah, defendant and several others were standing around the Pontiac. Although she testified that she told the police that she had seen defendant on Honor Street, she admitted that in her written statement, she never mentioned seeing defendant there. Quadajah denied having a gun or having seen the handgun seized from the Pontiac. On cross-examination, Quadajah testified that she thought she had seen two men in the backseat of the Pontiac while it was parked in the driveway. She admitted that she had not reported that to the police or told them that she had been on Honor Street that night. Damon Duffy had known defendant for 10 years, had worked with him, and considered him a good friend. He and defendant had worked together at Frank's on March 23rd to the 24th, 2014 at around 1 a.m. He and defendant left Frank's together in defendant's girlfriend's car. According to Duffy, they left with two other men, whose names he did not know. Defendant drove Duffy, sat in the front passenger seat, and the other two rode in the back seat. Now, this is where my question comes in. Is the defendant credible? They drove to Honor Street. They parked in the driveway, and all four men remained in the Pontiac. After discussing an upcoming party, the two people in the rear exited the vehicle. Duffy admitted that the cannabis cigarette was his. According to Duffy, there were two females in the vehicle, and he did not see Quadajah on Honor Street that evening. On cross-examination, when defendant's attorney referred to someone named Doug and his brother as being in the vehicle, Duffy recalled that those were the two men in the back seat. Duffy could not recall whether he mentioned Doug and his brother in his written statement to the police. The state recalled Officer Galarzo, who testified that when he asked Quadajah to describe what had happened regarding the Pontiac, she never said anything about being on Honor Street that night, nor did she mention Doug being there. The parties stipulated to the foundation an admission of the audio recording of the telephone conversation between defendant and Harris. A transcript of that conversation provided in relevant part that defendant told Harris that the prosecutor had said that he was a known gang member and drug dealer. Defendant stated that his attorney had said that because no fingerprints were on the handgun and the car was not defendant's, they could beat the charge. Defendant added that even if the police said that they saw him put something under the seat, there were no fingerprints on the gun. Harris said that the defendant had to make sure that they got little, especially Duff, when defendant asked if the state would call Duffy into court. Harris said, "I'm lost," likely when Harris added that Duffy needed to lay low a little bit. Defendant responded, "Right." When Harris told defendant that he had a chance of beating the charge, defendant responded, "Just like you said, I'm fitting the show, tell Duff, lay low." Shit. Harris then said, "Tell Duff we're going to unalive him." Defendant responded, "Oh yeah, ain't no ands, ifs, or buts." Harris immediately replied, "Hey, for real? For real though? What your lawyer suggests? A bench or a jury trial?" In discussing what we would do if he were charged, Harris said that he would deny that the gun was his. Harris added that when we caught that shooting, he had copped out to trial during jury selection. Defendant and Harris then discussed the advantages and disadvantages of a bench trial versus a jury trial. Harris noted that at the end of the day, it was not defendant's car, and defendant's fingerprints were not on the weapon. Again, referring to Duffy, Harris said that the best thing was for Duffy to just get lost. Defendant agreed. Harris added that Duffy needed to lie low until after trial, because if he testified, he would be confronted with his statement, which would affect his credibility. When Harris said that defendant did not want to go through that, defendant answered, "Stay low." Harris responded that when the trial began, they would get Duffy a room somewhere. Defendant said, "Yeah, a suite." So, again, my question is, the defendant, Quadajah, and I believe it's enunciated Khadijah, Monique Johnson, credible? And I ask that question because once you perjure yourself, or once you give an inaccurate statement, your word will always be made questionable in a court case. Being as though she was directly involved in this case, that I need to give also a shout out to Keys, because although I was searching for something else in the database, this case did pop up. I was searching for something totally different. I was searching for something to do with Latanya, which is Quadajah's mother. And this case showed up in the database. And so I read it in depthly. And I said, okay, I heard about this already from Keys, Big Keys. So I would like to give a shout out to Big Keys for putting this out on the front street, on the forefront, um, and speaking briefly on it. But however, to be able to read the court transcript from what took place, it made me question, is the defendant even credible in my eyes? And then wanted to know or ask the question of the individuals that, you know, may be subscribed to my channel and or may interact with me, and wanted to see, after reading it, how do you agree or not? I have to pee. Okay, I'm sure. I'm sure. Leave, Mom. Leave her. Nice. Go, Mom. Okay, so I am going to attach this to the to my channel. I'm going to add it so that way it can be read in grave detail by everyone as well. So that way you can see it for yourself and you can, you know, make your own sound mind decisions upon the question that I have posed, which is the defendant credible? Because up until I read that, I did not know, even from Keys just given the you know, the splice of a splash, not splice, I'm sorry, the splash of information that he gave us. You know, he didn't get into it deeply. He didn't go deep into it. So I just was able and blessed again. When you looking for something else, you end up finding something that you was not even looking for, at the same time that you're looking for what you are seeking. And to see that she has a problem with being honest, and that she will say things in order to protect the man that she's dealing with, it made me, I was taken aback. It made me take aback. It left me in a mindset to really think about what's really before me, because I still held a part of me, still held out a hope that she did not do this in a malice intent, with a malice intent. A piece of me still wanted to have hope that her actions and the inconsistencies that keep coming up is merely because the incident and everything surrounding it, you know, made her nervous, you know, knocked her off her square, right? And then I read the full outline of the docket, and I am like, okay, well, this is something that she does, right? The whole I'm a rider, the rider girl thing, the thing about being a ride or die, right? This is what she does, and she will do it even to the detriment of herself. Being in, possibly could be incarcerated. So I just thought it was very interesting uh, to see that she she testified before to do with a criminal case, and and was found to not be telling the truth. And because of my background, it's important for me to be able to decipher through all of the prejudicial information and be able to see, does it outweigh the probative value. And to get through these things, it gets ugly before it gets pretty. And it brought me to the understanding that guy, that the man in the middle, has a lot to do with this, and that the reason why he won't be accosted by cuffs is because the state has a strategy, and this putting him behind bars won't help the situation. And I know this is an unpopular opinion, but the state won't put him behind bars at this moment because we need him to feel free. We need him to feel that his testimony is only going to stand true and assist for the defense. Because most laymen or lay people don't have a sense of what legalese is and or how to articulate it and its most performative subjects. Litigating it, speaking it, understanding it, in my opinion, is not easy. So when you are taking the information and putting it into Chat GPT, and expecting it to give you the truth about the law compared to you reading the actual statute, just reading it, breaking it down by having a notepad, a loose leaf paper, even your computer to take notes, and then from each portion of the statute, break down every word that you see that you may have. Once you see a word that pops out and you know the definition, you believe that the Webster's definition of it is what that is, then that's when you take that and you look for the legal definition of it to assist in helping you understand the difference in English and legalese. And that is why there is people that are split. Because people are split because there are people that are feeding their supporters with inaccurate information. And they're not expressing to them directly what the statute says per each charge, per each attachment of whomever and whatever situation that is before them. Well, for me and my channel, that's what we are going to do. I'm never going to get on here and give anyone what they want to hear, lies, or chat GPT. I won't do it. It's either the truth, the whole truth, and nothing but the truth. So help me God. Or you won't hear nothing from me ever. Now, I may end up dibbling, dabbling with giving my opinion on what is taking place in regards to what's happening with the different, CCs that are not being honest, or the CCs that are Justice for Romika that, is not being heard properly or being lied on. Other than that, like I said in the beginning, I stand on my own. I'm not looking to be accepted in any group. I'm not accepted in any group now. And I am okay with that. I have always been a lone wolf, but I've never stayed that way. I'm a people's person who love people. Accepting and acceptance has never been my issue. But feeding the masses a lie and going to sleep at night knowing you did so, now that I have an issue with. And I refuse to do it. And when you see me post anything and then at the end it says, fair trial for Holly, so the sentence isn't overturned, or fair trial for Holly, so the verdict isn't overturned, has a purpose. We want the state to do their job. And winning the case is not the state's job. The state's job isn't to win. It's to tell the truth. It's to advocate for the citizens of that state. It's to advocate for the deceased. That is what our prosecutors are there for. And we as citizens, we have to do what we can to assist them in every way possible, so that way they can feel the support, and that way they can know that, listen, so long as you are implementing the truth and you have put the truth on the table and advocated it to the very end, that is something that I believe that we can all stand behind. Favor isn't fair.